the beginning is you need to put your insurer on notice. Hopefully you've got insurance policies that have all the right riders. If there's any doubt that you don't have the right insurance riders, talk to some agents that specialize in church and ministry insurance. I've got several friends who do that, and I send clients to them fairly often and it's free talking to them to get a good workup of whether everything's in place that needs to be in place. The sexual abuse, for instance, now is always a rider that's not included in basic insurance. Whether your amounts are high enough, the size of your organization, what your umbrella insurance looks like. That's really important because the insurance is hopefully what will pay for the litigation for you. Your life facing major litigation without insurance is going to be very scary. The insurer needs to be put on notice. This is a slightly squishy issue. Is that when the lawsuit gets filed? Is that when you first hear about the matter? If you get this wrong, your insurer could deny coverage. Not that an insurer would ever do such a thing, but you really want to err on the side of letting them know sooner. You'll notice that your policies have a clause that say if you don't notify the insurer, there's no coverage. In addition to picking up the phone and talking to your agent, it's a good idea to memorialize that in a letter or an email that we heard at such and such a date, and we let you know, and we'll keep you posted, and this may not go anywhere, but if it does, you know about it.
I had an attorney once just to make sure that our insurance companies did what they said so in the policies.
And sometimes you do. Sometimes litigation is about enforcing your insurance policy, which is also interesting, but more interesting for me than for you.
What do we need to hear in order to do that or start that process?
Something that could potentially result in a lawsuit. So an injury on your property, for instance, you would have to take it case by case. And if nothing ever happens with it, all you've done is you've told them we're putting you on notice. Communications with your insurer are not usually privileged at the beginning, and usually they become privileged after the litigation process. So investigations in the ordinary course of business are usually not privileged. And the real point of litigation is to figure out what a case is worth and end it at that point, when both sides agree that the case is worth about X. And that's really what the discovery process is for. It's only secondarily for preparing for trial. Right now, about 1% of cases are actually going to trial. So they settle in the process, which makes people like me very sad because we like to go to trial, but it's great news for the rest of you because you don't want to.